Hello everybody, Martin Radner here from Radner Law Group, bringing you trial analysis, and today we're going to be discussing the earth-shattering, news-breaking press conference from the defense team for the Alex Murdaugh, on behalf of Alex Murdaugh. So before we jump into that, please like and subscribe to this channel so we can continue keeping this channel growing, so we can continue bringing you this type of analysis. So we had a press conference today from the defense team for Alex Murdaugh. Now, they were just filing a motion for a new trial. Motions for a new trial get filed all the time in a lot of criminal cases, and certainly capital cases, they get filed. All the appeals get filed. Everything, you got to exhaust every single avenue to possibly make this person innocent. However, in this case was very different, and the reason is they filed a 65-page brief, and aside from the 65 actually pages of the brief, which were mostly for factual allegations and for legal analysis, they also attached affidavits. And these are affidavits attached that are from the jurors themselves, talking about potential jury tampering that occurred in this case by the clerk Rebecca Hill, or referred to as Becky Hill. She was the court clerk. She's an elected position, and the allegations that are made in these affidavits are just unbelievable. It just completely will shock any trial attorney out there, and completely shocked me when I heard about these allegations. Even the fact that these allegations are being made and they're put into affidavits are just completely shocking. Some of the allegations include that she told some of the jurors, don't be fooled by the evidence being presented. Don't be fooled by Murdaugh and the way that he testifies. Don't be fooled by the evidence that his attorneys present. She was having private conversations with the foreperson and then telling the foreperson not to tell the other jurors about it, and telling the other jurors about it that they can't ask questions about what happened in her private conversations with the foreperson. That the verdict shouldn't take you too long to come to. And then also, which is a little more famous about her, the situation with one of the jurors' ex-husband, who allegedly posted something on Facebook which turned out to get her disqualified as a juror, and that was a juror that the defense liked. They thought that they had the juror on their side. So I mean, these allegations are just mind-blowing. It's just things that you don't hear about. These are the things you hear about in the movies. You hear about jury tampering in the movies. Whoever hears about jury tampering in today's day and age? Everybody in the courtroom, especially by an elected official, every single person in the courtroom respects the process, all the attorneys. No one wants to even have the appearance of impropriety. And in fact, one of the jury instructions, and this is probably what a lot of lawyers, when they're hearing about this motion that was filed and hearing about some of the allegations that are made in these affidavits, one of the things that they're thinking about, and one of the first things that I thought about when I heard about this, was that there's a jury instruction that the judge instructs in every single case. In every single case, and this is just the language that it is in Michigan. I'm sure that there's very, very similar languages in every single jurisdiction out there. And this is how it goes in Michigan. To avoid, this is what the judge is instructing the jury, and he also tells it to the lawyers. To avoid even the appearance of unfairness or improper conduct on your part, you must follow the following rules of conduct. And one of the rules he says is, or she says, until I have discharged you as a juror, you must not talk to any party, lawyer, or witness, even if your conversation has nothing to do with the case. This is to avoid even the appearance of impropriety, which means that the lawyers are not allowed to have any sort of discussion at all with the jurors, even things that have nothing to do with the case. A lot of times you're stuck in the elevator with these jurors, or sometimes you can pass them in the hall, and just out of normal common courtesy, a juror may say, oh, good morning, Mr. Radner, or they may say, hi, how was lunch? Or just something to be polite or something to be nice. And as a lawyer, we're all trained that you don't even look at them. You look down, you completely ignore them. And the judge a lot of times tells the jury, don't be offended. The lawyers they're not mean, they're not impolite, they just don't even want to have the appearance of impropriety. And every single lawyer takes this very seriously, because we don't want any jury tampering. We all respect the process, and even though sometimes you're adversaries, you're against each other and you're fighting for each one's fighting for their clients, but you don't want to have you don't want to play this way. Nobody wants to play this way. Everybody wants it to be that there's a fair verdict. And to think that there's an elected official, the court clerk, who is doing some of these things, it just completely blows the mind and completely tears at every single trial attorney's heart, and it's just unbelievable. So again, now I want to make something clear. just like everybody in the world has due process, so does this court clerk has due process. Rebecca Hill has completely presumption of innocence until she's proven guilty also. So I don't want to automatically jump to conclusions. I don't want to even say that she for sure did this or even get mad at her or something like that. Of course, every single person has a right to due process, every single person, and she will also have her right to have her day in court to present her case or present her evidence or to talk about these allegations and and say her side of the story. Maybe it wasn't as bad as it sounds like, or maybe the jurors just completely understood that she was just asking them if they want some water, things like that, and they understood it to mean don't listen to the evidence. But these affidavits are very serious, and there's no question in my mind that there's going to be an evidentiary hearing. There has to be an evidentiary hearing based on these affidavits. Unless the judge, depending on what how the prosecutor responds to these allegations, I'm assuming the prosecutor would just say, we need to have an evidentiary hearing to see whether any of this holds weight and put the jurors under, questioning and put the jurors under oath and, have them go through cross-examination and see what actually was really said and maybe they misunderstood things. So of course, I think that quite obviously there's going to have to be a evidentiary hearing. But is there going to be a new trial granted? So based on the affidavits, yes. Based on just on the affidavits, a new trial has to be granted because the standard, and this is the standard in their jurisdiction, the standard is that a new trial should be granted unless it clearly appears that the subject matter is harmless and could not have affected the verdict, which means that the conversations that this elected official had with the jurors, if their conversation was on any subject matter, and then it's not considered harmless unless you know clearly that it's considered that would be considered harmless and could not have affected the verdict. Now, a conversation about don't trust certain evidence or look at the way that he's testifying or suggesting that there's some lying going on or that telling the jury not to believe certain things, that is obviously the subject matter which is not harmless. That's extremely harmful and certainly could have affected the verdict. So just based on the affidavits, yes, certainly under the law that is in that jurisdiction, there should be a new trial. But let's not jump the gun. Let's not jump ahead and say that that's for sure going to happen. Well, first, what has to happen is the Court of Appeals has to agree to stay the appeals that were filed in this case, and then allow the trial court to preside over this. Remand it back to basically the trial court for them to decide what to do about this. Again, generally speaking, there should be a evidentiary hearing, and then the question is going to be, well, who presides over the evidentiary hearing? We already have that this judge already had given interviews, he's already spoken kind of his mind, and therefore, he's already should be not be allowed to preside over this. So there has to go to a different judge to preside over this evidentiary hearing, and then eventually come to a conclusion. But just hearing from these allegations, it just rips at every single heart of every trial attorney out there, I know for sure. And it's very sad to hear about these things. And again, I don't want to take away the benefit of the doubt. I don't want to go against everything that we're taught, that everyone has the presumption of innocence. That's 100% true. And it could be that all these jurors are making it up, and we'll see how their testimony survives under scrutiny, with other attorneys cross-examining them. We'll see how that goes on. But certainly, I'd be completely shocked if there's not an evidentiary hearing, and from the way that these affidavits make it sound, that there very well could be a basis for a new trial. So, unbelievable, earth-shattering stuff from the defense team on the Alex Murdaugh case, and we will see. I mean, this is just thousands and thousands of hours that went into this trial by both teams, and now it's all for naught. And we're always told, this is something that I was told, growing up, and that is that you can live your entire life doing everything perfect. You can do everything, live everything by the book, be 100% above anything, and all it takes is one bad decision that you can make, and that will completely destroy your life. And here, Rebecca Hill could have been a completely innocent, well-meaning, good person her entire life, and for some reason, this trial came out. She saw an opportunity. She had as we know, she wrote a book about it. Then she had some speaking engagements, and she was promoting her book. And maybe she just got a little bit greedy, and that one poor decision that she made, and that she decided she's going to go try to influence the jury, that completely shattered her entire life. So, a tremendous lesson, whether this is true or not true, a tremendous lesson for all of us that no matter how good you act, no matter how responsible and moral you act your entire life, your entire life could be judged on one poor decision that you make. So you got to be very careful. And we'll see how this ends up panning out. And that is my take on this. I mean, all those thousands of hours that all the attorneys put into this case, and it might have to be all redone again. So we will see, and we'll keep you posted as the information comes out. So please, again, like and subscribe to the channel, and we will keep bringing you more trial analysis.